Okay, hello everyone. We might get started now on our webinar, What Will Happen to Your Online Life After You Die. Thanks so much for joining us. I hope you get a lot out of it today and that you learn something about this relatively new but very important area. Okay, so I'll just quickly tell you a few things about myself. My name's Natalie Darcy. I'm an accredited specialist in wills and estates law with the New South Wales Trustee and Guardian. New South Wales Trustee and Guardian is the largest will-making body in the state, and we've been around for 100 years, in the past known as the Public Trustee of New South Wales, now known as New South Wales Trustee and Guardian. So we've been around since 1914, around the beginning of the First World War, and we've seen quite a lot of changes in that time in how wills are written and what sort of gifts people leave in wills. No one would have imagined 100 years ago that we'd be sitting here today talking about digital assets and online life, that's for sure. And our 100-year anniversary actually coincided with having written our 1 millionth will, which is a pretty big milestone. So what we'll cover today, there's a bit to get through. First of all, we'll talk about why it's important to plan ahead and have a will, not only for your digital assets but all of your assets. Why is it important to have a plan in place, and what does your online life include? How to get started putting a plan in place for your online life, and we'll also talk about a few other things that you need to consider when making a modern day will. And there should hopefully be a little bit of time left at the end just in case anyone has any questions. I'll leave it to the end to answer your questions. And I'll give you a bit of warning as we're approaching the end so that you can start typing away your questions if you'd like. Now, on your control panel, you'll see that there's an option for questions. If you can't see your question box, just click on that plus sign there next to question, and that will expand out the question box. So today we're mostly going to focus on digital assets and how to deal with your digital life. But just before we get into that, to put it all in a bit of context, I'll just talk about why it's important generally to plan ahead and to have a will. So what assets do we need to think about when planning for our estate and planning our will? There's the obvious ones, the tangible assets, the ones we normally think about when we're making a will, like our real estate, cars, jewellery, furniture. Then there's the financial products, things like bank accounts, shares, superannuation, life insurances, and then we get to our online and digital assets. And this is something that's really only become an issue in the last few years. A decade ago, few of us would have imagined the extent to which we're living our lives online and the extent to which we rely on our computers and other digital devices, but there's no doubt now that it's something that we do need to think about in addition to all of those obvious things like our house and our cars and our bank accounts. So why is it important to have a will generally? Well, if you die without a will, there's legislation that determines where your estate goes and how it's going to be divided up. But every family is different, so the formula in the legislation may not be appropriate for your family and for your loved ones. Many of us have what can be described as a non-traditional family, whether that's stepchildren, raising children not biologically their own, same-sex couples raising children. Without a will, loved ones and dependents could potentially be left out or left without proper provision. If you have a will, you have a say who's going to benefit from your estate, no matter what your family situation is. A lot of people know there can be claims upon estates, wills can be contested, but if you have a will, your wishes are known and you've got a say. And the other really important reason to have a will is that when you have a will, you are choosing who's responsible for administering your estate. That's your executor. We see too many situations where people have died without a will, and there ends up being uncertainty and disagreements amongst their family as to who should be responsible for looking after their estate. And this can cause delays, not to mention the stress and the heartache associated with that. So on to our main topic for the day. What does your online life involve? So when we talk about online life, we're talking about digital assets such as your online accounts or memberships, and files you store on your computer, or you might store them on your other digital devices such as your iPad or your smartphone, or they could be stored in the cloud. And digital assets can have financial value, but many times they've simply got sentimental value, which can be just as important to people as the financial value anyway. So we've just listed there some digital assets that might have a financial value, and that can include things like frequent flyer points. It can be blogs or websites that might have high traffic and generate advertising revenue. It might be a PayPal account or an eBay account, and online gaming accounts even. And what can be done with these assets after your death depends on the terms and conditions of the individual service provider. So there's no one answer as to what's going to happen to these assets when you pass away. Just to give you a bit of an example, with frequent flyer points, some providers will allow for any accumulated points you've got to be transferred to another member account after your death, and there might be a time limit on that. For example, it may have to be done within, say, 12 months from your death. But other providers may say that the points can't be transferred, and the points simply end when you pass away. So it really just depends on the terms and conditions. Now, digital assets with sentimental value, and there's quite a lot of these. This can include things like email accounts, and I think most of us have an email account these days. Social media accounts, Facebook, Twitter, LinkedIn, Instagram. And again, I think most of us are on some kind of social media these days, so this is a big issue. Online games, digital music, ebooks, photographs. If you think about it, in the past, many of us would store our photographs in shoeboxes, or if we were particularly organised, we'd keep them in hardcover albums. Now you tend to keep, well, I know I do anyway, and I think a lot of people do. You might have 500 or 600 photos stored on your smartphone, perhaps with good intentions of printing them out, but sometimes it doesn't quite happen. Other things with sentimental value might include home movies and also blogs. And as with the financial digital assets, what can happen with these sentimental assets very much depends on the terms and conditions of the individual service providers. And I'll be talking in a little more detail about some of these sentimental assets shortly. So let's have a bit of a look at how many of us have an online life these days, and what are our online habits. These statistics that we've set out here on this slide were sourced from a survey commissioned by the New South Wales Trustee and Guardian. We were surveyed over 1,100 adult Australians, and then the data was then weighted to the latest population estimates from the Australian Bureau of Statistics. So it found, amazingly, that 9 in 10 Australians have a social media account, yet 83% of us who use social media haven't had a discussion with our loved ones about what would happen to our accounts when we die. And these are huge numbers. The rise of social media has just been so rapid, and now we all have to try and catch up with our planning. 57% of people believed that it is important that loved ones can access their digital photos after they've passed away, but not too many people have made arrangements as to how that would happen. And 45% of people thought it was important that their loved ones can access their account settings so that they can change in appropriate settings after they've passed away. For example, if you're familiar with LinkedIn, it may send your contacts an alert to suggest they congratulate you for being in a job for 5 or 10 years or whatever it may be. And you can imagine if those sorts of settings are not changed, or the account's not closed down when someone passes away, those alerts could really be quite upsetting for the family and friends. Now, our survey also found that 79% of Australians haven't discussed access to emails with their friends and family, and 95% haven't discussed access to cloud personal account and storage. And amazingly, and I was quite surprised by this, only 3% of Australians who have a will have decided what to do with their social media accounts in the event of their death. So look, this is certainly an area that many of us yet haven't addressed, and it's something that we do need to get onto. So why do you need to have a plan in place for your online life? Why are we bothering with all of this? Well, I think the first point is people are having more of an online presence than they ever have before. We're using computers and the internet just so much these days that it's an issue we can't ignore. We need to plan ahead because we need to ensure that our online records and assets can be found and accessed after our death. So, for example, do your loved ones know what online assets and accounts you have? Will they know if you have a PayPal account, for example? Or will they know where you store your online photos and how they'll access those? If you don't put a plan in place, those sorts of digital assets may not be discovered, or they may not be discovered for a long time. There are certainly financial reasons as to why you need to plan for your online life. Our digital assets can have financial value, and that might be, as I mentioned, some money sitting in a PayPal account. But it could be something else potentially quite valuable. For example, authors who have manuscripts saved on their computer. Leonard Bernstein, he was a composer and conductor. He passed away in 1990, almost 25 years ago, and it's reported that he left a manuscript for his memoirs, Blue Ink I think it was called, in a password-protected file. And despite many reported attempts by people to access that, it hasn't been successful, and you'd imagine his manuscript may potentially have quite a lot of value for his estate, but unfortunately no one's been able to access it as yet. Another reason we need to put plans in place for our online life is that with the rise of the internet and use of computers, we're losing our paper trail. So if you think about it, if you've ever acted as an executor, you may have gone through a person's house or office, gone through their personal papers to try and work out who they banked with, who their superannuation was with, who their telephone company was, all of those sorts of things. But now there's online banking. We may not receive statements or correspondence from the bank in the mail. We may simply get our superannuation account statements by logging in to our superannuation fund website. Even telephone providers, you often get your bill online now on the internet rather than receiving it in the post. So that paper trail is not there anymore. So it's really important that we think about the effect of that and make sure that our loved ones and our executor is aware of what we've got, so when the time comes there's not going to be delays in dealing with the estate and perhaps assets that or bills that aren't discovered. There are certainly sentimental reasons why we need to put plans in place for our online life. I mentioned before photographs that we often now store on our smartphones or our computers or on USB sticks rather than keeping hard copies of them. And as I say, many of us rarely get around to printing them out. And if your loved ones don't know how to access your photographs or where they are, a lot of memories and family history might be lost. Another reason we need to make these plans and think about our online life is that there can be inappropriate settings on social media that you may not want to be left to live on after you're gone. And I mentioned before that the LinkedIn alerts to your contacts. Facebook is another common one. If you're on Facebook, you'll be used to getting those birthday reminders, which can be quite distressing for people, I think, to receive those after someone's gone, especially if it goes on for some time, if their account is untouched. Another actually good example of this one from quite recently, Joan Rivers sadly passed away, and a couple of weeks after her death a post actually appeared on her Facebook and Instagram accounts promoting the new iPhone 6, and it was in typical comedic Joan Rivers style, but obviously it was a post organised before she'd passed away. And you can imagine how distressing that would have been for her daughter and her other loved ones to have that happen, because the way the post was worded, it was as if she was still here, putting the post on herself in real life. another reason we need to make these plans, you can make your wishes known as to what you want to happen with your social media accounts. So using the Facebook example, because it is quite common that people are on Facebook, your executor, when you're gone, has a say whether, or your loved ones, your next of kin beneficiaries have a say whether your Facebook account will be deactivated or whether it will live on as a memorial site. And there are forms on the Facebook website that need to be filled in, and certain evidence needs to be provided to Facebook regarding your death and the entitlement of the person making the request. But if the account is memorialised, it means it stays there, but it's locked down, if I can use that word. It means no one can log into the account. You can't change, or no one can change, add or delete the existing content. You can't add or delete friends. Automated posts like the birthday reminders will be stopped, and the account can only be seen by confirmed friends. Depending on the settings, friends might be able to share memories on the timeline. Now, online businesses is something we see more and more of these days, and something that wasn't around a number of years ago. If you have a business, even if you just have some online records, it's really important, very important, to plan ahead as to what's going to happen when you're no longer around. There might be sales orders that are done online that have to be fulfilled, bills to be paid, insurances to be renewed, so your executor really needs to know how those records can be accessed. The other big thing, the other big reason to plan ahead for your online life is to reduce the risk of identity fraud. Unused accounts of deceased people can be targeted by fraudsters. Personal information could potentially be obtained from the accounts, like credit card details, photographs, potentially addresses, email addresses, and actually quite a large proportion of identity fraud relates to deceased people. And possibly one reason for that is that the accounts are easy prey because there's often no one monitoring them. So it is important that your executor knows about your accounts, your email accounts, social media accounts, and can arrange for their closure or transfer, if possible, after your death. So how to put a plan in place for your online life? Look, it's a good idea to consult a professional will maker. There are this is about your making a will generally as well as your online life. There are so many legal requirements for making a valid will and for planning your estate. And the wording that you use in everyday life, when you put that down in a legal document like a will, it doesn't necessarily have the legal meaning that you intended. So it's not necessarily a straightforward process. It is a good idea to consult a professional. The other thing to be aware of when you're thinking about putting plans in place for your online life is to be aware that different online providers have different terms and conditions that affect what happens to your accounts when you die. And a good example of that is email accounts. Depending on your email provider, it may be very different what can and can't happen with your account when you're gone. For example, there are some email providers who are prepared to provide a data disk of the contents of a deceased person's account upon receipt of certain requirements, including proof of death and proof of identity of the person making the request when you're no longer around. There are other email providers, for example Google, which runs Gmail. They have an inactive account manager in place, and it allows users to request Google to contact them after a certain period of inactivity, which might vary from between, say, 3 and 12 months. And then if there's no response, the account can either be deleted or the contents can be shared with certain people that you nominate. And if someone dies without having activated that inactive account manager, then the executor or administrator can apply for access to the account, but it may not be granted. It may not necessarily be granted. Yahoo is another interesting one. The contents of the account and the account itself aren't transferable even upon death, so they'll close the account once evidence of death is received, but generally won't share the contents of the account with anyone. And there was a case in the US actually where the family of a US Marine tragically killed in Iraq sought access to their son's Yahoo email account. They wanted to have the messages that he'd written before he passed away. And the matter went to court, actually. His father tried to access his email account. He wasn't able to do so because of Yahoo's policy, which was to not give access to the account to anyone but the account holder. And their position, Yahoo's position, was that their terms of service require them not to disclose private email communications of its users. And the battle went on for some time, with Yahoo eventually giving the family a data disk containing details from the email account. So I think that all just highlights it's really important that you become familiar with the terms and conditions of your accounts. A lot of us, when we sign up to email or social media or whatever it may be, there's a huge list of terms and conditions, and I think most people just hit accept without reading it, but it really can affect what happens with these things. Another thing to consider when you're making plans for your online life is who's going to be responsible for looking after your online life when you're no longer around. And it could be your executor. In most cases it may be your executor, but it doesn't have to be. It could be somebody else. But whoever it is, you have to make sure that you can trust them implicitly, obviously, and it should be someone with some digital know-how, someone who's a little bit tech savvy. So how to put a plan in place for your online life? Well, the first thing, and a very good start, is to make a list of your online and digital assets for your executor. So, for example, you might write down that you have a Twitter account, a Facebook account, and store photographs online or on your computer. And you should also record what you want to happen to those digital assets and how your executor can access them. With your Facebook account, you may want to specify whether it's your preference that it would be deactivated or deleted, or whether you would want it to be memorialised, and if so, how long would you want the memorialised account to stay there before being deleted, perhaps indefinitely. And this list can simply be in a letter to your executor. One really important point I have to make is that you shouldn't include digital asset usernames and passwords and security questions in your will. The reason is, when you die, a number of people, including your beneficiaries, but not necessarily limited to your beneficiaries, will be entitled to see your will. In New South Wales, there's legislation that provides that that's the case. And also, when a will is admitted to probate, it actually becomes a public document, so anybody can, in theory, get a copy of your will once it's admitted to probate, provided they pay the required fee to the court. So to protect against fraud and to protect privacy, it's very important that those details aren't actually included in your will. So if you decide it's appropriate to record usernames and passwords and security questions and leave those details somewhere for your executor, very important obviously to store it securely, somewhere safe, and we'll talk a little bit more about that in a second. You may want to leave, for example, your access code for your smartphone or your tablets, plus some of your digital accounts. But there are some circumstances where it's not going to be appropriate to leave usernames and passwords. And one of those is banking details. Your online banking passwords should never be divulged to anyone. When it comes to your bank, your executor will provide certain documents to the bank, and the bank will freeze your accounts and then close them and pay the money into your estate. There's no need for your executor to have your online banking passwords, and they really should be kept secret. There can be serious consequences if those details fall into the wrong hands. Another consideration too, just for those accounts or devices where it may be appropriate to record your passwords and usernames, a good idea can be to keep usernames in one spot and passwords in another spot, just for a bit of added protection. Another thing to consider about passwords is that they often change. Many digital accounts or your computer may require you to change your password regularly. So if you are recording these details, it's not something you can do and then forget about indefinitely. You do need to keep updating it as you either get new accounts or as your passwords change. And look, it's really an individual preference as to whether people are going to record these sorts of details, their passwords and usernames, and the extent to which they do, because obviously there are some risks involved. You do need to weigh up those risks, the potential for unauthorised access to accounts, and there can be serious consequences if accounts are hacked, not least the potential for identity fraud. So it's something you do need to be careful with. And the other thing to keep in mind is that you might potentially be breaching the terms and conditions with your service providers if you make a written record of your access details and if you give those access details to someone else. And your executor and your beneficiaries may be breaching the terms and conditions as well if they try and access your accounts after you die. So using the example of Facebook, it's actually a violation of their terms and conditions for someone else to try and access your account. So if you have a Facebook account when you pass away, your executor or your next of kin need to go through the proper channels and request closure or memorialisation of your account via Facebook, rather than simply using access details to log into your account and try and shut down the account or change the settings that way. So where to keep instructions for your online life? Now there are a few different options. For example, a safe place at home with a trusted family member or friend, and that may be your executor. There are online businesses that offer to store information for a fee, and some of them it might be a one-off fee, or it might be a monthly or a yearly fee. These online businesses are sometimes referred to as digital vaults, but you need to keep in mind that there'll be a username and password to get into that digital vault to get all of the passwords, so that username and password would have to be stored somewhere as well. Another option is a safety deposit box, although that may take a little while to get access to after your death, because a bank, there'll be certain documentation they require before they're prepared to release the contents of the safety deposit box. So whilst that's certainly an option, it may mean your executor can't get quick access as they could if you kept them with a family member or friend or at a safe place at home, for example. But wherever you decide to store these details for your online life, and whether we're talking about storing passwords or just simply the instructions that you've left listing the accounts you've got and what you want to happen to them, the most important thing is that you make sure that your executor and your beneficiaries and your loved ones know where that information is kept. Now there are some limitations on passing down your digital assets. In many cases, your digital music files, such as iTunes and also ebook files, can't be passed down to beneficiaries. And this surprises a lot of people, particularly people who may have collections worth thousands of dollars, which does happen. But the reason is that the terms and conditions provide that you have a license to use these files. So in the case of music, you've got a license to listen to them, but you don't actually own them. A couple of years ago in the media it was reported that Bruce Willis was considering legal action against Apple because he wanted to be able to leave his iTunes music collection to his children. And it doesn't seem that that legal action ever happened, so it may well have been just a rumour, but it certainly had the effect of making people aware of the issue, that they simply can't leave their digital music to whoever they want. And the other limitation, which I've already touched on today, is that while different email providers have different terms and conditions, some email providers don't allow access to emails of a deceased person. So that means if you are in the habit of storing a lot of important information in your email account, you do need to consider other ways to retain the information or documents. And some people might keep a lot of photographs in their email account that people have sent them or that they've sent other people. So if that's the case, it can be a good idea to make local copies. Which brings me to maintaining personal digital archives. Now, in case your loved ones do have difficulty accessing your online accounts, it is a good idea to think about making a local copy, because records and memories could be lost, particularly in the case of photographs and home movies. It would be quite devastating for for people to lose all of that, all of those records. So consider periodically downloading and storing digital files and keeping a local copy, such as on a removable hard disk. But the thing to keep in mind is that storage methods change as technology changes, and so it may become necessary to update the storage methods as time goes on. Years ago we used floppy disks, but they don't seem to be around anymore, so if you had information on a floppy disk, it could be a challenge to try and extract information from those. And it'll be interesting to see in 10 years' time if the storage methods we're using, like USB sticks, will still be usable. Who knows? So when you're making a modern day will, what are some other things that you need to consider? The Intestacy Laws. Now, intestacy refers to when you pass away without a valid will in place, and they actually changed a couple of years ago. About 45% of Australian adults don't have a will in place, and actually the statistics are worse for parents with children under the age of 18 years. I think it's about 60% of Australian adults with children under 18 don't have a will. So unfortunately, quite a lot of Australians end up with these intestacy laws applying to their estates. And I say unfortunately because they're not appropriate for every family. We have a lot of what we could describe as non-traditional families these days. So there's no one size fits all. Now, I mentioned these laws have changed in 2010, so they're quite different to what they used to be. And the laws I'm talking about here are New South Wales intestacy laws. It can be a little bit different in each state. One example of the changes was to the entitlements of siblings. So if you don't have a will and your closest living relatives are your brothers and sisters, so if you have no spouse, no children, and your parents predeceased, then your siblings would be entitled to your estate. Under the current laws, your whole-blooded siblings, so siblings that you share two parents with, are entitled equally with your half-blooded siblings, ones that you share one parent with. Whereas under the old laws, whole-blooded siblings had preference, so they would receive your estate entirely to the exclusion of any half-blooded siblings you have. Another major change was to the entitlement of spouses and children. So this changed quite substantially in 2010. So now if you have a spouse and you have children, but all children are to that spouse, so there's no children from earlier relationships, then the spouse actually gets the whole of the estate, no matter what it's worth. But if there are children from an earlier relationship, it's a little bit different. What happens there is your spouse would get the first $440,000 from your estate, approximately. It goes up and down with the CPI, but they'd get the first $440,000 from your estate plus half of what's left, and your children would share the other half. So using an example of a $500,000 estate, your spouse would get $470,000 on a $500,000 estate, and the children would share $30,000 between them. With a $1 million estate, the figures work out with the spouse getting about $720,000 and the children sharing the rest, which is $280,000. So it's really important that your wishes are set out clearly in your will, because, as I said, these intestacy laws may not be appropriate to everyone's family situation. Actually, I say recent, but it was about 8 years ago now, Peter Brock passed away in 2006. And he had what we can probably describe as a non-traditional family. He had a former partner that he'd been in a relationship with for many years. They had 2 children together, and his former partner had a child from an earlier relationship that Peter Brock apparently treated as his own, and he also had a new partner, a current partner, when he died. Unfortunately, he didn't put proper plans in place for his estate. It appears that he had started the process of updating his will, but he didn't finish the process, and he did it without legal assistance. So his loved ones were involved in a lengthy and costly legal battle to try and sort out which of his wills, if any, was the last valid will, and ultimately the court found that his estate had to be distributed under the Intestacy Laws. Now, this wasn't in New South Wales, so the laws were a bit different. But ultimately, in his situation, it meant that his children were entitled. It was reported that his current partner, made a claim on the estate which was settled. But no doubt, if he'd made a will and had some professional assistance making that will, it would have made things a bit easier for his family, and I suspect it would have made it far less costly for his estate as well. Now, another thing to consider when making your will is the choice of executor. Many people automatically appoint their closest relative or their closest friend as their executor without really thinking whether that's the best thing and whether they're best suited to the job. We always say it's not really a compliment to be nominated as executor. It's not like being chosen as a bridesmaid or a groomsman at a wedding. The role of executor can be quite onerous and involves dealing with legal and financial issues. When you're an executor, you may end up having to sell property, sell a family business, or perhaps wind up a family business. You may have to set up trusts and ensure investments are managed. There can also be tax issues to deal with. So it's quite important to choose someone who's up to the task and who's willing to take on the task. When you're thinking about who's going to be executor, it's a good idea to ask the person if it's a job that they're willing to do. And look, you can appoint an individual, or you can appoint a couple of people as your executor, or you can appoint a trustee organisation like New South Wales Trustee and Guardian. Another thing that really needs to be considered when you're making your will that I think probably escapes a lot of people's minds is what is going to happen to your pets. Now, look, there are over 38 million pets in Australia, so there's more pets than people. And 63% of households in Australia actually have a pet. So this is a big issue, an issue that a lot of people need to think about. And a survey we did show that 90% of pet owners believe it's important to consider who will look after their pets when they pass away. And that's not surprising because a lot of people do think of their pets as being like part of their family. And it is possible to leave provision in your will for your pets, which a lot of people are surprised at. And some of the options are setting up a trust. So you can set up a trust that will go on for a number of years throughout your pet's life, so that there's money there to cover expenses, including veterinary care, all of those sorts of things. And if you're setting up a trust like that, you need to choose the trustee that is prepared to carry out the terms of the trust and who's prepared to do the right thing. Another option is a pet legacy program with an animal charity. Some animal charities and welfare organisations have these programs where you can leave them a sum of money and then they'll take on the responsibility of rehoming your pet or housing it at a facility that they might operate. If that's an option you're looking at, you do need to contact the charity or the animal welfare organisation and find out what their specific requirements are. They may have particular requirements as to what sum of money needs to be left. Another option is to make a legacy to a friend or a family member and request that they care for your pet. And obviously you'd want that to be someone who's going to care for your pet as you would, and it needs to be someone that you can trust. You don't want to do that and then they take off with the money but don't take on that responsibility of looking after your pet. And it's a good idea to think about what amount of money is appropriate, what is it likely to cost for the rest of your pet's life, and think about what an appropriate amount of money is. Another option is euthanasia. Sometimes people take the view that their pet would be too distressed to go on without them. If this is an option that people are considering, it is something that should be discussed with the executor of the estate to make sure they're comfortable with it, because ultimately it's going to be up to the executor to make those arrangements if that's what your wish is. And there are a couple of recent examples of celebrities leaving provision for their pets in their wills. Relatively recent one was Lauren Bacall, who passed away this year. She was reported that she gave her son $10,000 so that he could take care of her pet dog Sophie. Another thing to consider when you're making your will is, many of us consider our friends as being like family, or perhaps closer than family in some cases. If you do want your friends to inherit anything after you're gone, they do need to be included in your will. Their friends are not going to be entitled on intestacy if you don't have a will. Storage of your will is an extremely important consideration. In the survey we conducted, we found that close to 40% of Australians store their will at home in a filing cabinet or drawer, but it isn't the best option. About 11,000 homes are destroyed by fire each year in Australia, and on top of that you've got floods and other accidents, even theft. The Supreme Court of New South Wales, when you pass away, they require your original hard copy will. So whilst so many things happen online these days, your original will is still required. And if your original will is lost or if it's been accidentally destroyed, whilst your loved ones can apply to the court seeking to deal with your estate as per the lost will, there are a number of things that have to be proven to the satisfaction of the court, and if it can't be proven, then the wishes as set out in your lost will won't be fulfilled. And look, even if the court is satisfied that you still intended that document to apply, and even if the court is prepared to say that yes, your estate is to be administered as per that lost will, even to get to that stage it will have cost your estate likely many, many thousands of dollars in legal costs. So that's money obviously better going to your beneficiaries rather than in legal costs. So it's very important to consider safe storage of your will. And the best way to safeguard your will is to store it somewhere secure, such as New South Wales Trustee and Guardian's Will Safe. The Will Safe was launched recently. You don't have to be a New South Wales Trustee and Guardian client to store your will in the safe. It doesn't matter how you made your will, you're able to store your will here. And there's a charge of $49 including GST for storage of a will, and you can also store your power of attorney and enduring guardian documentation as well at no extra cost. There's just one last thing I wanted to mention before we come to the end of the presentation and before we get to questions, if anyone has any. So feel free to start typing away any questions that you might have. But the last thing I wanted to mention was, in addition to your will, there are a couple of other documents that you really do need to consider putting in place to make sure you've got a proper plan for the future. With Australia's ageing population, unfortunately that brings with it an increase in age-related illnesses like Alzheimer's disease, dementia, strokes. So it's very important to not only have your will in place, but also documentation which deals with your assets and your lifestyle while you're still around, being a power of attorney and enduring guardian. So a power of attorney is where you appoint a person or a trustee company like New South Wales Trustee and Guardian to make financial and legal decisions for you. And that could be in place while you've still got capacity to do it yourself. It may be, for example, you're going overseas on a holiday and you want to make sure there's someone back home who can look after your affairs for you. Or you can make what's known as an enduring power of attorney, which continues to apply after you've lost capacity, if that ever happens. So having a power of attorney means that your attorney can basically do anything that you can do financially for yourself. So they can withdraw money from your bank account to pay your bills, they can purchase assets for you and sell assets for you. An enduring guardian is a bit different. Whilst the power of attorney deals with your financial affairs, your enduring guardian is where you appoint someone who's going to make decisions about your lifestyle, medical treatment and your living arrangements. And unlike the power of attorney, the enduring guardian only comes into effect when you're not able to make those decisions for yourself anymore. And it probably goes without saying, but for both the power of attorney and enduring guardian, you have to choose someone that you can absolutely trust. With the power of attorney, for example, they have quite a lot of power over your financial situation, so it certainly has to be someone that you trust to do the right thing. And the important point about those documents is don't leave it until it's too late. A lot of people do, unfortunately, think when I about and they leave it until they may have got to a situation where they're not able to understand what those documents are about. So get those done before well before you think you may need them. So this comes to the end of the presentation. Let's see if there are any questions coming through. We've got a question from Patricia. She's asked, does a certified copy of your will become applicable should the original be lost or destroyed? Well, look, the answer to that is that certainly may be helpful. If the original will is lost or destroyed accidentally, so that the person who made the will didn't purposely destroy it or throw it out with the intention of revoking it, if there is a hard copy, a photocopy available, then that can certainly be presented to the court. Evidence has to be provided as to the intention of the deceased person, that they still intended and wanted that to be their will. So that certainly does help. It can still involve quite a lot more cost than if the original will is available. So Francis has asked if there's a possibility of getting a hard copy of today's webinar presentation, and so we can certainly arrange that to be emailed. And if anyone does want to have a hard copy of the presentation, if you can just send an email to Georgina, Georgina, at darcypr, darcypr.com, and we can certainly get that through to you. We've got a question from Angela regarding cancelling of direct debits after death. Look, what happens with those sorts of things? Your executor, or hopefully you've made a will and you've got an executor, your executor would make contact with your bank shortly after the death, provide them with a death certificate, and those sorts of things would be cancelled. Your account would be frozen, and then your executor needs to make arrangements for payment of any of your outstanding accounts. We've got a question regarding, so this one's from David, how can an executor deal with bills being delivered online? Look, that's a really tricky one, because I presume we're talking about here bills that come through on email, and look, a lot of the times your executor may not have your password for your email account, but it may be against the terms and conditions of your email provider for somebody like your executor or anyone to access your email account when you're no longer around. It just may not be appropriate for them to do that. So it's extremely important to leave a list for your executor of all of your assets, of all of your accounts, all of your liabilities, so that they can then make contact with those organisations as soon as possible after your death, let them know you've passed away, and make sure that any accounts that need to be paid are paid. And look, this is quite important for a lot of things. For example, insurances. If you're getting your insurance accounts online, you want to make sure your executor is aware that there's an insurance policy, and if it's going to lapse, it obviously needs to be paid so that your assets are protected. We do have a question from someone who has said that they missed the first part of the presentation, and is it possible to get a recording? We are planning on putting this onto New South Wales Trustee and Guardian's website. I'm just not quite sure how quickly that will happen, but we'll try and get it done as soon as we can. So if there is anything that you missed or you wanted to go over again, you can certainly have a look at that on our webinar. Oh, okay, sorry, we've got a question that Harvey has asked if I could just repeat that email address. I do have a habit sometimes of talking too fast. So the email address that you can send to if you would like a hard copy of the presentation, it's Georgina, so Georgina at darcypr, darcypr.com. Okay, we've had a question from Faye just regarding how she can find out about different laws in Victoria. Look, for any of the different states, the law in relation to wills and estates is actually different in all of the states and territories around Australia. So one option is you can contact the equivalent of the New South Wales trustee and guardian in those other states. In Victoria, that's known as the state trustees. In some other states, it's known as public trustees. So if you get in contact with them, they'll certainly be able to give you some advice regarding the wills and estates law in those jurisdictions. Okay, that looks like we've got time for today. Look, I thank you very much for listening to the presentation. I hope that you've got a lot out of it.